May I most humbly pray that it may please be taken up at 12 p.m. today, subject to the convenience of the court.
Today we are rising early only after the admission.
After
Sorry.
the admission.
Yes.
I'll, if I may be permitted to try.
Hey, you can try. What is the urgency?
The urgency is, Malad, what has happened is in a suit for declaration that the agreement between the petitioner's late estranged husband is binding on the petitioner. Learned Trial Court in an application under Order 11, Rule 12 and 14 of the CPC filed by the petitioner, that the income tax returns for the relevant years be directed to be furnished by the plaintiff. The Learned Trial Court rejected the same on the ground that it cannot be allowed at the current stage, which is cross-examination of the defendant. My lord, whereas Order 11, Rule 14 clearly says at any stage.
No, but what interim order are you seeking?
Stay of the order which rejects the direction of production of the income tax returns. My lord, she claims in the suit.
No, yeah, rejection order, how can it be stayed?
My lord, stay of the proceedings, my lord, as well.
You know the provisions, what are the preconditions of the application filed?
Yes, my lord.
For seeking leave.
If this application is not interfered.
When is the next date?
26th of July.
We'll have it on the reopening. We'll apply some mind.
My lord.
You have it on the reopening.
My lord.
15th. Have you filed it or not?
I have filed.
We'll have it on 15th. Next date is, if you make out a case, you might get an order.
Deeply.
I beg to mention item 1 and 2.
Yes.
The conducting counsel, Mr. A. Mubarak, is out. Let the matter after.
No, these are all admission matters. MSc will admit this. Why are you seeking time?
Actually, whatever the conducting counsel is out of station.
Okay. Do you have the file or not?
No, Lord.
File is also not there.
Yes, sir.
These are 19 matters for admission. You be here. We'll record your name. If there's no problem, we'll admit this appeal. Okay.
May I please, Lordship, with the consent of other side, I beg to mention item number 8, Lordship.
Eight.
For
8. Yes.
8, Lordship, for order.
Order matters you did not mention. We are only taking up admission. We have to rise early. Okay.
Prayer for listing of a transfer petition, my lord. If a lot will remember.
When?
Today, my lord. Yesterday, one transfer petition had to be withdrawn because the page was missing.
Today, it will be difficult.
As the last item, my lord.
Can you bring it now?
Yes.
If you can bring it, we'll have it.
Highly obliged.
Item 18, I think an AK Pulpest is LDS is on the way, my lord, so I'll request it.
Who?
AK Pulpest.
Is there any urgency?
Urgency is that, my lord, this is the applicant is not necessary party, as we understood, and we pray for decision under 1 Rule 10(2). And this court has not passed any order said at this stage, so you cannot understand what is decision. But our anxiety is that, my lord, Form 50 is not given. That is why we are unnecessary, because our land is not boundary man of
So what is the urgency?
Urgency, my lord, in that sense, my lord.
There is no urgency.
Urgency is that sense, my lord, this building is not completed because bank
That
has
is
said
not an urgency. Urgency is something which is going to, orders are going to be passed, otherwise something terrible is going to happen. That's not the case. We can have it on the reopening.
Notice maybe issued. I will satisfy your lordship this 94 page. My lord, this is the map, my lord. It will make clear. Then 3 shielded schedule. It will clear that I am not a necessary party. My lord,
you are the petitioner.
I am the petitioner, but in title suit I am defendant number 1 and 2.
Defendant, petitioner, 2 petitioners.
Yes.
2 petitioners here.
Here.
They are the defendant numbers 1 and 2.
Yes, in title suit.
Title suit for?
Title suit more declaration a passage inventory right on the passage. But the land falls in the defendant number 3. 1 and 2 is made party, my lord.
Inventory right. Then what happened?
My lord, that we have filed a petition, my lord.
Yes.
For deletion of the name because we are not a necessary party to the suit.
Why?
Because, my lord, our plot
You
is...
filed an application for your deletion.
Yes, my lord.
That you are not necessary parties.
Yes, my lord.
Let us see the order.
My lord, 153 last page, my lord.
court,
You make the prayer, if it is rejected, we are there. First appellate court, how do you renew, make a new prayer?
pending disposal of the
No,
application.
no, but
Your lordship has the power.
no, Mr. Sharma, that the point which you are trying to raise now, that point was never raised before the trial court.
No,
Let the
that-
trial court be approached, you file an application, let it be decided. We cannot assume that it will be decided against you. It may be decided in favor of you. Till disposal of the suit, you may not be, the shop may not be demolished. You file an application, we can make an observation, but we are not going to. As an appellate court, first time for such kind of a prayer will not entertain.
My lord, in that case, my lord, some observation.
We'll make an observation, you file an application, we'll admit this appeal. Mr.
Yeah.
Okay.
Yeah.
Heard Sri Yashi Sharma, Learned Senior Counsel, assisted by
And call it.
Ann Kolita, Learned Counsel for the appellant. Please have your seat. The also heard Sri,
For respondent number 1, 2, and 3.
no, it also heard Eternal, yeah? Eternal. Admission to. The instant appeal has been preferred against an order dated 5/6/2024.
Yeah.
Passed by the learned civil judge, senior division number 1, Kamrup Metro, in Miss J case number 370 of 2024, arising out of title suit 205 of 2024. Full stop. The appellant is the plaintiff in the title suit which has been instituted for declaration of tenancy. Full stop. Along with the suit, the aforesaid Ms. J case was filed for injunction with a prayer to remove the lock to the chat house, you call it chat house, which is in the premises of the Guwahati University. Full stop. The aforesaid by the impugned order, comma, the aforesaid prayer has been rejected. Full stop. Para admit. 3. Yeah, for 1, 2, and 3.
Yes, sir.
Why? Who is 4?
4 is
the,
state officer, my lord.
State officer,
By name. Why have you
By
named
name.
by name?
because there are some grievances against. me.
Okay. 3.
Is a Fukan.
Huh?
1, 2, and 3.
No, you are the standing counsel, Mr. Fukan.
Yeah.
Okay. Sri PJ Fukan, let the standing counsel accepts notice on behalf of respondent numbers 1, 2, and
3, my
3. Let extra copy. You have a memo of appeal, I think.
lord.
Let an extra copy of the memo of appeal along with the enclosed documents be served upon him. Let steps for service of notice upon the respondent number 4 be taken by usual process. List after 6 weeks along with a report on service upon the respondent number 4. You right. Heard Sri A.C. Sharma and Senior Counsel for the petitioner who by means of this petition filed under Order 39, Rule 1 and 2, has prayed for injunction pending disposal of the appeal. Full stop. The connected appeal has been filed against a prayer for injunction pertaining to removal of a lock from the chat house of the petitioner, which has been rejected. Full stop. The prayer made in the present application is almost similar to the injunction petition which has been rejected. Full stop. Para. Let notice be issued enabling the opposite parties to file their response. Steps again, 4 to hurry. usual process. Since the prayer for ad interim injunction is almost analogous to the subject matter of the impugned order, comma, the same is rejected at this stage, full stop. However, comma, and at this stage, comma, the senior counsel for the petitioner prays for a liberty to approach the trial court with a prayer for injunction pertaining to the aspect of removal of the chart house from the premises, full stop. The petitioner is at liberty to file such petition, which, however, is required to be considered strictly in accordance with law. There is no prayer for removal here also. In
Well,
the IA.
By the subsequent event,
No, you have not made a prayer, so otherwise also you could not have granted. Best if I approach the trial court. But we are still issuing notice on the injunction application. Let them show cause.
some interim protection may be granted. but
What
the-
kind of interim protection?
If in the meantime, the
That is not even your prayer.
interim prayer,
No, that is not even your, only to remove the lock. The removal of the lock is the subject matter of the appeal. We have, now if we cannot grant the final relief.
removing the lock. And the,
You file an application, we have made an observation, it will be considered. Yes, next.
Also,
Yes.
Worship, the present appeal arises against the impugned order. Is at page 46, whereby my prayer for ad interim ex parte injunction was rejected by the learned trial.
Appellants are the plaintiff.
Yes, my lord.
Suit for?
Suit for declaration that the Schedule A property is an HUF property. And the fact of the matter, my lord, if I may take, my lord, to the cause title of the appeal, the suit is between the family members.
Okay,
The
this
petitioner
injunction was for what?
injunction for restraining the respondent number 4 from further alienating the suit. That aspect of the matter was not discussed in the order. Our say is that the suit property is the HUF property, which is
Yes.
represented by the Karta, who is the respondent number 2.
Hmm.
Now, respondent number 2 has sold the property to respondent number 4. So when we came to know, we challenged the sale deed because the Karta cannot alienate without there being a legal necessity.
But is the sale deed under challenge
Yes, sale deed under.
by which respondent number 4 has accrued some right over the,
Yes, my lord.
Hmm.
So now,
where is the order?
my lord, the order is at page 46 of the FAO.
46.
46.
Yes, please read.
I'm reading the operative part, my lord.
Please.
Yes. On perusal of the pleadings and materials on record, it is seen that the OP number 2, who is the Karta of OP number 1, that is Mrs. Jagdish Prasad Agarwala and HUF, transferred the suit premises, that is 3 kattas 6 lachas of land to OP number 4 by registered sale deed executed on 28/10/2022 and registered on 23/11/2022, which is a part of HUF property. The petitioners, being the co-parceners of the HUF property, challenged the sale deed on many grounds, including that of deceit being played by OP number 3 and 4 in obtaining thumb impression of OP number 2. It is averred that an oral family settlement took place between the co-parceners of HUF and the Schedule A property, which is inclusive of Schedule B property, was thrown in the common stock. It is further averred that the OP number 2, who is admittedly the Karta of the HUF family, cannot dispose of the HUF property without the consent of all other co-parceners, and the suit premises was not transferred out of legal necessity or the benefit of the state, and for discharging indispensable duties, and therefore the registered sale deed is bad in law. As the suit property,
Mr.
there-
Rai, Mr. Rai, is there any apprehension of
my lord,
further alienation?
yes, my lord. Now, my apprehension was that respondent number 4 may further sell.
That is it. Is there any apprehension
Yes, my lord.
of further alienation by respondent number 4?
Yes, my lord. That is why there is a prayer for ex parte ad interim injunction, because, my lord, after transfer of the suit property in the name of respondent number 4, who is the grandson, and then no sale consideration amount was actually paid. Now, the separate patta has been issued in favor of respondent number 4. So when the dispute arises and when we came to
But
know,
when did you institute the suit in 2024?
my lord, we came to know on 28/5/24.
But
Because,
this sale deed is of 2022.
my lord, in respect of the over the suit premises, there
Okay.
are
Part 3 AK Rai, Learned Counsel for the appellants who has preferred this appeal against an order dated 11/6/2024 passed in so-and-so by so-and-so, whereby only notice has been issued in the aforesaid miscase filed for injunction. Full stop. It is contended. Injunction. Para, admit. Let steps be taken for service of notice upon the respondents by usual process. List on 26th, 29th July for service report. Record call korona koriba nalage. Record no koriba. Heard 3 in the miscase. I heard 3 VK Rai, AK Rai, Learned Counsel for the applicants who by means of this application under Order 39, Rule 1 and 2 of the CPC, read with Section 151, has paid for injunction. Full stop. The applicants are the plaintiffs in title suit number so and so, number 280 of 2024, instituted before the learned civil judge, along with which Ms. J case number 517 of 2024 was filed for injunction. And by the impugned order dated 11/6/2024, only notice has been issued. Full stop. The connected FAO 53 of 2024 has been admitted today. Full stop. Para. 3. Rai, the Learned Counsel, prays for an order of injunction protecting the rights of the parties. Full stop. It is submitted that the scheduled property is admittedly an HUF property, and the same was sold to the respondent number 4 by the respondent number
2.
Opposite party number 4, by the opposite party number 2 on the strength of being a carta, however, without taking the consent of the applicants who are co-personers. Full stop. It is also averred that such sale was not due to any necessity of the HUF. Full stop. Para. Issue notice returnable on same date, huh? Steps. Same. Para. Pending return of notice, this court directs that the interest of justice and balance of interest of justice will be served and the equities will be balanced by an order of an interim injunction. Full stop. It is accordingly directed that till the returnable date, the opposite party number 4 is restrained from alienating the Schedule
B property.
B property. Also, the aforesaid order being an ex parte 1, the same would be reconsidered on appearance of the contesting respondents.
Hello.
Contesting opposite parties. Okay.
My lord,
You take steps immediately.
yes, ma'am.
Google, no? Out of Ubuntu.
Item 5.
এটা আনিম বুলি কৈছিলে নহয় কিবা item 5 Mr. B Chetri none appears for the appellants on call in spite of names of the council being reflected in the cause list. Full stop para. In the interest of justice, matter is adjourned to be listed after the vacation to give another opportunity after the summer vacation. এটা মেনশন কৰিছিলে যে কিবা এটা অৰ্ডাৰ্ছটো নলওঁ এটা দুটা দি দিয়া কিবা আছে যদি আহে যদি চাওঁ অৰ্ডাৰ্ছ নলওঁ বুলি কৈছিলোঁ কিন্তু অৰ্ডাৰ পাছ কৰিলে বেয়া হ'ব ন তেওঁ আহিলে মাতি দিলে হ'লে বাৰু যদি আহে ন আজি নহ'ব আৰু কেনেকৈ মই কৈছিলোঁ আনিম বুলি এতিয়া মোৰ যাব আছে এতিয়া আজি নহ'ব